Good afternoon, members. It's 1:38 p.m. and I call this Ways and Means Budget meeting to order. Before us, we have the chairman of the Commonwealth Casino Commission. Thank you, Chairman, for making yourself present. We do have a quorum today. And with that, can I get a motion to adopt today's agenda? There's been a motion, been seconded. All those in favor say aye. All those opposed say nay. The ayes have it. We'll move on to the public comment section. I believe there's no one in the public that would like to make comments with regards to the Commonwealth Casino Commission's budget. And with that, the chairman of the Commonwealth Casino is here. I believe Mr. Yom is here on with the. Are you presenting, Mr. Yom, today or no? Okay. With that, thank you, Chairman, for making yourself present. We understand that we don't fund the Casino Commission. However, this body is tasked to look at all the resources available, and since the Casino Commission is part of the revenue generating part of the budget, the committee would like to hear as to how is the commission still operating and what assistance does the commission need to complete its task moving forward with the gaming here in the cinema. As you know, we had history, and I believe the cinema benefit from the casino. But where do we stand now, and how do we move forward? And with that, I'll now hand over the floor to you for your opening statement. Thank you.
Thank you, Mr. Chairman, and honorable members of this committee for the invitation to appear before you this afternoon and discuss not only our budget, but also some of our recommendations on where I think our gaming industry should be in terms of moving forward, if that is what the intent of our policymakers are. Um, the This is a long story, Mr. Chairman, and I'm not quite sure how exactly to approach this. But when Public Law 1856 was passed, at that point in time, they imposed a $1 million non-refundable application fee for any vendors responding to the RFP to the gaming. There were two vendors, IPI and Megastar. Each one of this company was required to deposit a $1 million non-refundable application fee. The $1 million from one of them is where CCC first got its budget to operate. We never got CNMI local funding. 1856 designed it so that the operator would be the one to pay, not the taxpayer. Um, in the 1856, it also authorized the commission to have to impose to establish regulations as necessary to implement 1856. In that regulation, it empowered the commission to assess fees. We did so, and at that point in time, after a year, the $1 million we started was getting depleted. So we started assessing as soon as the commission actually organized in January 2015, and we passed our regulations about April 2015. We imposed fees on each employee for regulatory fee of $250 per year. The key employee was $1,000 per year. The machines were the first 100 was $125 and $100 thereafter for every machines. Tables were $250 per table per year. That's how we initially assessed our fees to because we have no local funding. Several months into it, we realized that we only got barely $280,000 or something like that, not enough to operate. So we came before the legislature, and also IPI came along with the management, and we met the late governor, Eloinas, and we discussed how the commission can exist because we were preparing to close the door because there's not enough money to operate. At that point in time, that's when it came out, Public Law 1924 was developed, where CCC was given the authority to, um, basically, the law authorized the imposition of $3 million for IPI to pay as a flat fee. So it doesn't matter whether at that time IPI was looking at 4,000 employees for the Garapan facility, and it was looking at 12 to 15,000 employees for phase one and phase two. So recognizing that, and also in the machines from a few hundred to potentially thousands of machines. So they recognize that the flat fee of $3 million actually is favorable to to IPI. So that's in 1924. It says that the $3 million, which increases by 5% every 5 years. That's why you see 3,150,000. Um, that's earmarked for the Casino Commission, but that we need the legislature to appropriate it every year. So we follow the Planning and Budgeting Act. When they call for budget, we put together and we submit how the commission needs the funding to justify the 3,150,000. Based on our experience, um, we established five divisions. That's the executive division, the permit and licensing division, enforcement and investigations division, compliance division, and audit division. Um, and we spend an enormous amount of time, Mr. Chairman, on training. Now that's how it was operating. And I might add that despite all the negative experience that everybody has with IPI actually remarkably performed very well on the gaming. Where they really messed up was on the non-gaming, specifically labor and construction. And I keep hearing rumors about money laundering and so forth. I have not seen to date any indictment against IPI on money laundering for gaming. The only money laundering that we've seen done was for the labor-related violations. So when you look at it, all of the negative aspects that have happened with IPI, for some reason at all, CCC has been accused as being responsible to enforce everything and anything under the sun. Now, we started all of these enforcement actions against IPI since 2020. And in 2021, we actually had two evidentiary hearings to basically charge and prosecute IPI for specifically five violations. These are the non-payment of casino license fee, non-payment of the regulatory fee, non-compliance with the CCC orders regarding payroll reserve, and related violations. On the hearing, the executive director prevailed, and we assess a suspension of 6 months suspension and a fine of $6.6 billion against IPI. This is back again in early 2021. They filed an appeal to the Superior Court. Unfortunately, Superior Court took quite some time before they deliberated and resolved. And Judge Bogdan at that time affirmed the CCC's ruling. Then IPI again appealed to the CNMI Supreme Court, our enforcement. Again, Supreme Court has their own schedule in terms of having the oral argument, but it finally came out in early 2023 affirming the CCC's initial ruling, except for the period of the COVID, where they deducted 1.6 million from the fine. That's why it moved from 6.6 million to 5 million, where the fine still stands. So, in a nutshell, that's basically what happened. We are not responsible for labor. As you all know, the federal government is responsible for that. We're not responsible for OSHA. We have no authority on that. On the labor issue, by the way, we tried to get our CNMI labor, and we were informed that if employer has more than 500 employees, they sort of lose jurisdiction and it goes to the federal labor department. Um, we call all the regulatory and all the permitting agencies so almost every month when the commission meets to ask them for help because IPI had a line of lawyers that every time we move left or right, they reminded us we have no authority over those non-gaming. Um, and rightfully, 1856 did not grant us the authority to do constructions or building. Now, recognizing that, we amended our regulations to require that all non-gaming vendors doing business with IPI in excess of 250,000 a year must be licensed by CCC. We had a lot of pushback by IPI, but that the regulations authorize us to do that. All gaming, by the way, it doesn't matter the amount, are required to be licensed and permitted, but the non-gaming. So, and if you're doing business with more than 250,000 a year on any 12-month period, you're required to be licensed. This is after we realized that MCC had violated a lot of the construction issues. And again, we have no authority over construction. Public Works implement the building code, not CCC. We call Public Works in on every meeting that we have, on every monthly meeting. And we ask them, please enforce that. We stand by you, and we will be your secondary enforcement if you have an order and they're not complying. We can help you out on that one. Now, what happened, Mr. Chairman, is that throughout uh, throughout their experience, I would admit that although we are policemen for the industry, there was quite a lot of really drastic, horrible events that have happened in our Commonwealth between Super Typhoon Sodilor, Super Typhoon YouTube, and then COVID came and just closed the door. Now, in the casino license agreement, which was executed between, if you back up a little bit, the license was granted by the Lottery Commission to IPI. The Lottery Commission at the time was the Attorney General, Secretary of Commerce, Secretary of Finance, and the Department of Public Safety Commissioner. These are the entity that awarded the license, that did the suitability review on them. Now, in that license agreement, there's section 2 there that says that the office of the governor shall be responsible for the enforcement of the terms and conditions of that agreement. CCC handles the gaming part. But there's also an important part of that agreement, Mr. Chairman, that ended us in legal battle for more than 4 years. There's a provision on that agreement that says force majeure. It's a French word that says it's kind of like an act of God. So they claim that Typhoon YouTube and COVID was as a force majeure. And because of the force majeure issues, there are excused or forgiven from requiring to perform the agreement. And they're saying that they're kind of like the license fee, the regulatory fee, and those fees are not due because of COVID and because of YouTube. And the force majeure provision provided them that legal authority. Now, this is not just verbiage. They took us to the Supreme Court, I mean, the CNMI Federal Court. Federal Court issued an injunction, ordered us to go into arbitration. By the way, the arbitration is also part of the casino license agreement, even though on the same agreement, it says that revocation of your license is not subject to arbitration. Judge Manglonia disagrees and says, nope, you are subject to arbitration and you are ordered to arbitrate. I told the AG, how can we arbitrate? Because the arbitration, we pay 50% of the costs. I said, how do we pay 50% when we have zero? And the AG says that if we don't, we're going to be contempt of court by the federal court. I said, how could CCC be in contempt when we're not even a signatory to the casino license agreement? This is getting impossible. And he says, well, if you don't, the Commonwealth will be. And I said, I almost walk out of there saying that's your problem. But anyway, I said, so what can we do? What can we seriously do to save the Commonwealth? I was told to go to the governor's office and beg for whatever money for the arbitration. Now, again, recognizing this was an order by the federal court, I went down and asked the former governor to please help out on the arbitration. We ended up getting, I believe, a reserve $350,000 from former Secretary of Finance. CCC never used a portion of that for the arbitration. It went into the AG's office. They're the ones using that money to arbitrate in Honolulu. I was here from 5 o'clock in the morning to 1 o'clock in the afternoon, helping them on Zoom on the arbitration. Since we have no staff whatsoever since mid-January 2023, no staff at all. So I, as as chairman, had to step down and assist the AG in prosecuting the case. That's part of the reason I was barred from. I have to recuse myself from the subsequent hearing because the Administrative Procedures Act prohibits anyone who is prosecuting to be a judge too. So as a consequence, I could not sit in on those hearing on the revocation hearing. But at any rate, we appeal that decision by order by Judge Manglonia to the Ninth Circuit Court to say this arbitration should not have been ordered by the court. The Ninth Circuit Court agreed and ordered the order to be reversed. We immediately contacted the arbitration company and said, cease all operations because we are no longer going to pay a penny. So the Ninth Circuit Court says the arbitration was not needed. The order by Mona Malone was reversed. IPI took us to the Supreme Court, U.S. Supreme Court, for a writ of certiorari. The U.S. Supreme Court eventually said, "Okay, that's not. We're not going to hear that. It's denied." So we're back. They still took every member of the commission individually and professionally, and the governor at the district court. We're still in litigation against us, now personally too, for enforcing Public Law 1924 and for attempting to sanction them. This is, and mind you, we went before the governor, previous governor, begging for help. Can we get something to at least pay the phone, pay the rent? Nothing. Uh, I requested Governor Palacios early in the year, can we at least have just to go through this hearing? He granted us the 2.5 months only of, I think, using ARPA, and that's over, no more. So we temporarily got the executive director for 2.5 months, and then we just to have the hearing, the revocation hearing. So, Mr. Chairman, as you know, there were several efforts for IPI and CCC to enter into stipulated agreement. And in the stipulated agreement, which I personally got involved for almost 2 years to try to see how we can, because at the end of the day, what we wanted to do is make sure IPI find a way to pay the 15.5 million a year for casino license fee and the 3 million regulatory fee, and to also pay all the vendors that they owe, basically comply with the CCC order. Now, our interest at this point in time is for IPI to finish the building in Garapan and to figure a way to pay the people that they owe. The casino license agreement, Mr. Chairman, in my opinion, is the first experiment by the Commonwealth government to implement a truly integrated resort project. The Public Law 1856 is so huge, it required the investor to invest a minimum of $2 billion and construct a minimum of 2,000 new hotel rooms of five-star quality, a convention center, a water park, and over $100 million worth of entertainment team. So in this agreement, as I said, it's an integrated resort with a gaming component added into it. Now, it was designed to be implemented in 3 steps. The first step was supposed to be the initial gaming facility, which was the Garapan facility. That is the first step. The second step, which actually where the main core of Public Law 1856 is phase 1 and phase 2. Phase 1 and phase 2 is where the 2,000 rooms were supposed to be built on the convention center. Well, phase 1 never happened because IPI had a major struggle, major difficulty with public land, securing the land to build their facility in Marpi. Now, they also entered into the casino license agreement, which is not part of the law, which is the community benefit fund. The community benefit fund of $20 million was supposed to be in effect 60 days after groundbreaking on phase one in the MARPI. Phase one never happened. But since they were not able to complete the Garapan facility based on the very ambitious plan of the casino license agreement, they requested the Lottery Commission for extension of the completion date of Garapan. And I believe it was amendment number 5 or 6 to the license agreement, that the Lottery Commission agreed to extend the completion of the facility, provided that they move up the $20 million that was due 60 days from groundbreaking, move up to 2018. And that was part of our complaint to them on the enforcement actions, was that you failed to pay the community benefit fund. And the license agreement was for specific reasons, and the money retains at IPI and it is to be disbursed in consultation with the governor. They barely spend much money on that, and we monitored every penny, and there are records, paper records of how those were disbursed. Now, so where are we now, Mr. Chairman? CCC does not have any budget since IPI was supposed to pay every year 3,150,000 on October 1st of each year. The last time we received was in the 2019. So starting on 2020, we realized there was problems, so we tightened up the bill really, really, and we just basically not spend much. But by the end of 2022, whatever money we had was down to zero. So we had to lay off everybody in early January 2023, and we closed down CCC. But our casino regulations require that the commission meets every month. The commissioners, we're not by law, we're not employees of the Commonwealth, but we are required to meet. And this is an issue that I had a long discussion with our former legal counsel, Mike Ernest, after our Typhoon Sodiler, that all of the buildings are damaged, no power. How can we meet? And I said, you have to meet, even if it's under the plane tree anywhere. Uh, so based on that, we had some discussions with our 5 commissioners, and he says we need to continue to do our mandate. We need to continue to try our best and meet at least once a month in pursuant to the requirements of the regulations. Are we being paid? No. Are the people on Rhoda and Tinian, do they pay for the trip? No, they pay their own. They pay their own transportation to come up. Um, and yet people still saying, too expensive and so forth. So it's been about a year and a half that we've been doing this, and hopefully someday it would be resolved. But you call this meeting, Mr. Chairman, and in due respect to your committee and respect to Public Law 1924, and in respect to the call for budget by OMB, we submitted the budget that you have before you. I understand, based on what I'm looking at, that the governor again gave us $2 from the local funding. But our local funding, I suppose, was not entertained. But we are hoping that the legislature would appropriate the 3,150,000. Even though if you appropriate, we don't have it because uh, it's not available. But we need the authority to move forward. Um, Similar to all the previous appropriations since 2020, we do the same, but we have not received a penny from IPI. Now, Mr. Chairman, I think, seriously think that there is room for this industry to assist the Commonwealth in revitalizing our economic situation, but it cannot be under the current exclusivity. I understand why it was exclusive at the time. Anyone who's been following our retirement program, retirement fund, would realize that we will not have a retirement program if not for this particular program. But I think time has changed, and I think now is an appropriate time for the legislature to seriously look at uh, removing exclusivity and perhaps entertaining additional licenses however number you wish. I recommend that it be no more than three, just to be able to manage the three. Now, IPI is asking to reduce the license fee from 15.5 million to at least 5 or 6 million a year. I say the only way to do that, because the Commonwealth government needs that 15 million. Initially, it was for to restore the 25% that was cut from the retirement. It was subsequently changed by the legislature, but I understand that that bill's already back again to reserve that money for the retirees. So if IPI is if we're going to reduce down the license fee, then the way to retain that necessary amount is to increase the number of license and have everyone pay 5 million or 6 million each until you reach the 15 or whatever millions you will need for the retirement program. That goes for the regulatory fee to should be proportionally shared with all the licensee. Now, Mr. Chairman, I can tell you based on our experience that when we hired a lot of people, a lot of criticism were that we know very little to nothing about casino regulatory responsibilities. We spend significant amount of resources training our commissioners and training our staff. We sent all commissioners and the main staff to University of Nevada at Las Vegas, and I can assure you that our enforcement are probably some of the best enforcement in gaming you'll find anywhere in the world. Our compliance team equally, including our audit team. We went through and exhausted all of the UNLV curriculum, from enforcement to compliance to auditing and gaming. Even commissioners were given the boot camp on how to manage this properly. It was based on this experience that we came back and established what we call the minimum internal control standards. This minimum internal control standards is like the Bible for the CCC. This is a summary of all the standard operating procedures on the gaming. So when you walk into the casino floor, from the time you look at security, the time you look at surveillance, you look at cashier, you look at drops, you look at it's all on that we call it mix minimum internal control standards. So every member of the CCC is fully aware, fully trained on the mix to enforce the necessary regulatory aspects. And by the way, Mr. Chairman and members, one of the concerns that people have in reference to gaming is the federal law called the Title 31, the Bank Secrecy Act. This is where you would find the Anti-Money Laundering, Anti-Terrorist Financing Act. The situation on Tinian, where the IRS did an undercover investigations for close to a year, actually, and ended up with Tinian receiving the largest single fine by FinCEN, 75 million. Now, the key person at the federal IRS, his name is Kenneth Hines, is based out of Seattle. He oversaw, I think, more than 6 or 15 investigators, IRS investigators, and a guy named Gregory Lisa out of FinCEN. When they retired, IPI hired both of these individuals to come out here and make sure that IPI complies with Title 31. And we spent an enormous amount of time with Kenneth and Gregory Lisa establishing the necessary policy for IPI to make sure that every member of IPI, every employee of IPI understands the anti-money laundering provisions. And every year when we certify employees, we will not license them until we see a complete certification by Hines on the money laundering training. Now, this is we had arguments with them regarding that. Other than the gaming people, why are we requiring drivers to undergo money laundering? Why are we requiring housekeeping to go to the money laundering? And I normally tell them, what happened when the housekeeper finds a box of cash under the mattress? Or what about if you see that driver's loading up a box of cash under the truck? Absolutely required. So we train every member We did not impose this subsequent on the construction people because we figured they're third party employees and they're not doing stuff directly with access to the rooms or to the gaming machines. But Mr. Chairman, when we license machines, no matter what part of the world, the operator must apply to the CCC for license. We go through due diligence on these manufacturers, and we work with international, uh, U.S. and regional law enforcement in looking at them. Now, so every machine that is sold, and IPI fortunately all bought all new machines. We Since slot machines are no longer the drums, they are all computers. There's a group called GLI, Global Laboratory International. This is a global organization that sets standards, sets what those computer certifications are. Their standards for each of the gaming. We require that all machines be subject to GLI prior to being purchased by IPI. They need to be tested at the site by a proof tester, and then when they're shipped, they send to CCC the certifications and the audit for each machine separately to me at the CCC. When it arrives at Saipan, those machines were taken out of the container. We normally work with customs, so we're notified that the machines are here. We work with customs and we accompany those machines down to, in the case of IPI, to the San Antonio warehouse, where they are taken out of the container, set up on the floor, and they start testing them up. When they turn on, we require IPI to get a GLI personnel from Australia because we're handling out of Australia, and we send our entire compliance team down to the warehouse. And I receive separately from the tester of each of the machines certifications and audit the source code for each machine, like a fingerprint. At the time, we also bought a machine called Cobatron, and Cobatron tests the chips basically for each of these machines. So thank God these machines are new, so they're actually self-diagnostic themselves. But we go machine by machine, and we take out the reports that was given to me directly by the tester from wherever they purchased them. And that time they got them from Las Vegas, they got them from different parts of the world. Now, when they meet the source code for each machine, that's when we move on to the next phase. And the next phase was they would then take it apart and bring it down to the casino floor. At the casino floor, those machines have to be linked up into the casino case management system. IPI is required to have a case, and this is every casino should have a casino case management system that locks all of the machines and all of the money making entity into the computer to track the revenue. Now, they would have to operate those machines 24 hours to make sure that they are what we call the interoperability tests. When it's starting to talk and it's starting to communicate with their case management system, then they would request CCC for authority to go live. We would have our staff, our compliance team, our enforcement team on each of these machines. When they are ready to be certified, we then put our CCC seal on the top. We put them on the top because we have one of the most sophisticated surveillance system anywhere you find in the world. IPI purchased when they had the duty free. They were using the Australian security camera. When they moved to the new facility, they bought a German surveillance from Dahlmeier. When they send their people, we send also I think 6 of our CCC staff for over a month to Germany to learn that surveillance system, to learn how to record, to learn how it works. When they came back, our staff for enforcement investigations were some of the best trained people on that surveillance. There's more stuff in there than we could tell you, but it's so sophisticated that we can actually count your mustache from up in the eye in the sky. So we have a serial number once the machine is locked. And also in our office at IPI, we have a separate machine, a separate computer that can track the performance of each of those slot machines. So if an employee wants to see what you're doing, we can watch you on the camera, we can look in our own terminal upstairs and watch your playing. And this is all being recorded. Now, this is kind of like, and I want to extend to our colleague from Tinian. Remember, we were training your staff too, because you guys came out. And your staff were operating like 20 years before, for 20-year experience. And they were surprised to see the specifics that we were doing. We were also was starting to implement a tracking system from overhead, but we never got to that point. But the camera was so sophisticated that we could track if we suspected you to doing things. We can track you, and everybody you talk to would be tracked to separately. It was so sophisticated, and there are thousands of machines, thousands of eyes down there. We just cannot tell you how many, because that's confidential. But on this mix, that mix, in my opinion, is confidential document. I know a member of this body before attempted to do an open government act, and I told her that I am sorry, we could not reveal the mix because the mix has very confidential information in it, and it was designed as an internal operating procedures. But when it comes to security, we have to approve the security layout. We have to approve a certain protocol that we don't want anybody else to know what they are. The other one is also the your business day. If anybody were to walk up and say, "What is your business day?" that should trigger what we call the suspicious activity report. Because why would anybody would care what your business day is, unless you are staggering your play? Because when you reach $3,000 on those machines, it triggers you need to identify yourself, your ID. But you can stop before the business day and wait to turn over before you reach that, and then starts again from zero. And you're layering it, and that's we're watching those. These are part of them, and the anti-money laundering. So if anybody says, "What is your business day?" to IPI, it should trigger a suspicious activity report, and that report is a written report and given to us too. Uh, and it also tells us about your time at the drops. The drops is when they take the money out of the machines, they take the money out of the tables, and the route on how you move that money to the account room. And once you enter to the count room, there's also a protocol that we don't want anybody else to know what those protocols are in the count room. Um, but every day, Mr. Chairman, when IPA takes all the money down and rolls it to the count room, we have eyes on those activity. We monitor all the transactions. Whenever it's fully counted, there's 3 or 4 layers of reporting every day. One of the layer is CCC must receive a copy of those revenue, and that revenue goes into our audit, headed by Charlie Atalik before, and then we monitor the daily activity. When they issued their BGR, we looked whether or not what we have received, whether those revenue were reported properly on the BGR, and we do this regularly. Now, like I said, there's an enormous amount of activity that CCC does that we do not report to the public. Uh, and I tell you what, I give credit to a lot of the staff that have an opportunity to work in CCC, and I also give credit to Mike Ernest, who helped us a lot in drafting the regulations and in doing the preliminary enforcements. We were doing a massive amount of enforcement against IPI that we were not reporting regularly to the public, was most an internal sanction. An example would be on the 2019 casino license fee. IPI was late on the payment, and we issued an enforcement action against IPI. And as a consequence of the enforcement action, we imposed a $25,000 penalty every day that they were late, and it came up to a 375,000 penalty against IPI for making late payment on the 2019 casino license fee that went to the general fund. So, Mr. Chairman, I come before you with some suggestions actually, and I saw the speaker and the president, and I submitted some couple of pages of recommendations that what can we do differently. Some of my colleagues from Macau was expressing their concerns that um, CNMI and Macau were similar in the sense that we do not have the land mass necessary for our gaming. And they said in Macau, the first thing they would do is identify the lot, identify the property. Then they will put out an RFP specific to that property. So the problem with the CNMI is that you open up the RFP, and then you tell the operator, the willing vendor, good luck, you go find the land yourself. Now, this is not from CNMI. They don't understand our land laws. They don't understand what to do here. So they're recommending that if we ever revisit this industry expansion, that it would be it would be recommended. Identify your lot, identify your property. Where do you want the Commonwealth to construct your casinos? And work with in our case, I say we work with public land, we work with the AG, we work with the governor's office, we work with the legislature, historic preservation, and everybody else involved in the permitting, and say, is that where we want it? Let's say, for purpose of discussion, do we want it at the former Can Pacific area? If that is the area, then the RFP should identify that that is the parcel of land in which the Commonwealth wants you to build a casino that comprises X number of million of investment and X number of rooms, rather than just saying, in here it is.
I think, Chairman, sorry to interrupt.
Yeah.
We already have the casino here in the cinema. I guess what I'm trying to get at is, where are we? Are we revoking the license? You're coming before us now with recommendations
Yeah.
to add additional license. I'm not sure what I'm getting at here.
Okay. I tell you, like I said, I'm not quite sure the parameters of what you want me to discuss, but um, the revocation hearing that started, and the CCC was in the deliberation to make the decision to revoke. This process was interrupted with numerous offers for settlement. The commission was proceeding with the revocation when IPI filed the bankruptcy, Chapter 11 bankruptcy.
So what does
This,
the
yeah,
bankruptcy have to
I
do with the
was,
license?
there's a provision on the bankruptcy that once they file, there's an automatic stay. In other words, we cannot move forward with the deliberation or to revoke, primarily because the revocation involves money. If there's a specific section that could exempt the automatic stay, but most of those exemptions deal with public safety and kind of immediate safety issues. In our case, it was a money based violation. Now,
So why are you suggesting we're to
no,
amend the law?
uh,
And you're talking about there's a stay, and now you're here, or you've sent I guess you say you spoke to the
yeah,
speaker and the president with regards to, aren't you sending
no,
mixed messages about you?
no. I think, Mr. Chairman, I think first of all, IPI was voluntarily surrendering exclusivity, saying that they're willing to surrender exclusivity.
They have
To
approached you and said
Yeah, yes.
is
That's
there a document?
no document yet, but
So what authorizes you to speak to them on behalf of
uh,
amending the law?
well, my discussion with the attorneys involved here is that if the Chapter 11 has been filed and we have a stay, we should wait on hearing what the bankruptcy judge says. Just for your information, yesterday I did sign another declaration which our Attorney General is pursuing, um, and requesting the court for an exemption to the stay to allow the commission to continue its revocation. That was just filed yesterday, I believe. I signed the declaration yesterday, uh, asking the federal bankruptcy judge, can you waive the stay to allow CCC to proceed? We cannot act ourselves. We need to wait for that stay. On the other hand, I believe on the meeting that I was with the Attorney General and the Governor and the rest, they are seeking Chapter 7. They are seeking liquidation. And I suppose that if an IPI is saying to us verbally that if there is no settlement with CCC, and if there is no chance of them getting their license back, then they have very little chance of pursuing Chapter 11. And if that's the case, then most probably because of the amount of liability versus the assets, the Chapter 7 would be what the Commonwealth government would pursue at the bankruptcy court.
Isn't it kind
To
of weird that the district court says sell your items, and now the district court is telling us hold because they're gonna file Chapter 7 or Chapter 11? So I don't get there's a
Yeah.
disconnect somewhere between
By
the
the
two.
way, the automatic stay includes those people on the receivership. So those people who have already gotten a federal court order to receive, they're also on stay.
So last
They
week there was a container in front of iPad that was loading stuff. So who authorized that
I believe those were the ones that's already been authorized and approved by the
prior
court.
to the
Yeah,
court?
prior to the stay, prior to the bankruptcy filing. Once you file a bankruptcy, by the way, the bankruptcy in the casino license agreement, it says that if you file for bankruptcy, those are considered material breach that would justify termination of your license.
So what's
I ra-
preventing you from doing that?
I raised that issue, and I was told that that provision of the
Who told you?
the lawyers,
Which lawyers?
both sides, federal and
Can you
again
name
our,
the lawyers that are
uh,
on our side
uh, uh,
so that we're clear with everything and
uh,
not?
I think almost all of the AG's office and also the attorney for IPI have said that the bankruptcy provision, and Mr. Chairman, we looked at this thing because this is not specific to the Commonwealth. This is anywhere who has gaming license. We looked at the history of this bankruptcy issue, and this is a case in which the CCC's authority to revoke the license is based on what we call the police power granted to the state. The bankruptcy is a federal law granted to the vendor who's filing. It's a protection, it's a federal protection against the people who like CCC. So this is an absolute clashing of a state police power, whether it's CNMI or Nevada, versus the federal protection under the bankruptcy. And I'm
Yes, so
sorry,
we're under federal right now. That's
yes,
what you're
yes,
saying.
it trumps our regulation. It trumps our state police power. So we're we're saying,
So how
okay,
many months are we into this now? Once is the filing
according
of?
to Attorney Glass, who's representing the Commonwealth, this should be pretty quick because it's not in the hands of IPI.
Yeah, usually it takes 4 to 6 months.
Yeah, it says it's in the hands of the federal bankruptcy judge now, not IPI. So, but what I'm saying, this is not unique to the Commonwealth. Nevada Gaming Control Board, based on my communications, is saying even them, once the operator files for bankruptcy, they cannot just pull out the license, even though it's in the agreement, because it's a federal protection. And the federal supremacy clause says state stand down. So I don't think that at this point in time, the most that we can do, Mr. Chairman, is if IPI, and this is something that's been made clear, and I think it's been made clear publicly, IPI wants, and you ask yourself, I ask myself, what is in the best interest of the Commonwealth right now? How can we get that $62 million that they owe the Commonwealth for the retiree? How can we get the money that they owe CCC? And I know that the money they owe to the tax is paid, must be paid first
No, I
before anybody.
understand. But before you continue, because you're telling us now to amend the law so we can have IPA keep their literal license and give the district court their license. Then we'll create a three license, a new one, so we can start new. That's what you're.
Well, I'm just giving some suggestions, but I'm not necessarily saying that. Uh, IPI has filed for federal protection. They have submitted Exhibit A and B. And the B, they first of all they requested the court for authority to borrow 7 million from a Chinese, and of that 7 million, they have to exhibit. Exhibit A was to pay off the employees, pay the rent, and that was approved. $400,000 was approved 2 weeks or so.
So now the
Uh,
district court is allowing certain
yeah,
things to
yes,
go through.
yes, they allowed the 400,000, of which DPL got 200 some thousand. Now on Exhibit B is where 3.1 million is proposed for CCC and $3 million proposed for the CNMI government. That's 6 point something million. That's either today or yesterday. If the court approves that, and again, It's from that $7 million that they borrowed some individual.
which is in
Um,
the control of the district court, correct?
this yes, yes, yes.
Did CCC file a claim against IPI?
We have a standing claim for 62 million for the casino license
So
fee. So,
maybe the cinema should drop that so that we can allow
well,
the additional license. So we don't have any claim. They can have their own little
Mr. Chairman, I am suggesting that to the governor, to the AG.
also,
I said, look, this is back in May. They're saying that by June they're gonna take care of this thing. Why don't we just give them one more month? Why are we fighting this thing? If they liquidate that, what do we get? Penny on the dollar? Seriously, I mean, what are we gonna get if they liquidate it? I mean, I heard that Kingston was sold for 20 million. They're probably gonna be looking at 10 million for IPI. Who's gonna get what? So best if we can see what we can do. I said if we give them back the license, we're not giving them the authority to go live. We're just saying they give us back the license.
we
They
never took back the license. They still have the license. You're
no,
saying that
we suspended it. They don't basically they can't have it yet until CCC
okay.
gives them back. Which
Let
which
me before we can
we have
recognize my
yeah.
hold on. I'll recognize my vice chair. I think he has some clarification.
Um, Mr. Chairman, good afternoon. Welcome and thank you for joining us this afternoon. I thank you for sharing some of the history of what's transpired so far. Now that you can share out publicly. Um, I think a lot of the confusion here is IPI is recommending opening up the license to 3, 5, whatever, and that's the position of CCC right now. But neither IPI nor CCC has the authority to give license, and neither IPI, CCC, or the Lottery Commission has the authority to change the law. What what's dangerous in getting to that point, if we amend the law, it opens doors for IPI to file a lawsuit against the central government, because now we're opening to 3 license and they're still obligated to pay that $60+ million plus the what $15+ million that they owe CCC. That would put the cinema in a worse situation. And I know that you had mentioned that the $65 million or plus is supposed to go to the retirees. Currently, it doesn't. It doesn't, and we all know that 20-10 removed that authority. And there's a sitting bill. It's a bill multiple times been introduced after 20-10 that we've been trying to make sure that we put it towards its true obligation. The push of the casino industry being legalized in the CNMI was to address the retirees. Unfortunately, 20-10 changed that, and there are sitting members in the commission that were authors to 20-10 and supported 20-10 to remove the authority of those funds to be designated for retirees, but rather open it up to the senatorial districts. That's very unfortunate because it took away the guaranteed funding and relied on the gross revenue tax, which was beautiful back in 2018 and 2017, but we've never seen anything like that after. Can you just, I guess, if it's possible to answer the question, is what's the standing of the license today?
if I may just very quickly comment on that. CCC was really concerned when the legislature changed the purpose of the 15 million back then to use it for their own local general fund. We came up and spoke with the then speaker to say, do not attempt to do that, because that was first of all the reason what we thought was the gaming was casino allowed, because for the retirement, do not touch that. That's guaranteed. At the time, they were saying, I was a director. Don't worry, we got $40 million here and there. I said, you should really worry. And at that point in time, I shared something with the, uh, the speaker. I said, look, there is currently an ongoing internal battle that IPI was claiming that they overpaid the taxes. Um, On the gaming, there's a rolling chip program, and there's a this rolling chip program is that you are entitled to a certain amount of rebate, loyalty. They don't want to call it commission; they want to call it loyalty. And so whatever the VIP plays, win or lose, you get that amount. Now, my agreement with Mark Brown was that those amounts are subject to tax. They agreed, and they were paying tax. And then their lawyers got smart and said, by the way, you're not supposed to pay those tax because they're revenue not recognized. And it's called revenue recognition provision of the IRS. And we contacted several of the attorneys and said, is this true? Our own audit manager says it is true that if they do not recognize that, then they should not be taxed. They overpaid the Commonwealth. And I spoke to the speaker and they said, if they claim this and they get away with it, you are not going to see any more of your BGRT, and there might be zero tax because to offset what they overpaid. Now, the only thing CCC could do is revisit the rebate, either eliminate it completely to say, because in the minutes, and we had discussions with Mark Brown, the former CEO, look, in the minutes, we repeated to you several times that the commission would approve this percentage if you agree that it will be subject to tax. And you agreed, you said, yes, it's on record. And he agreed, said, yes, we said it's on record. Then I said, then you cannot reverse your position because your lawyer says so. And he said, sorry, the law says we don't have to. What we said was on the meeting. And we were preparing to basically eliminate all this rolling chip program. But then this is when it started to collapse if type of Solar and YouTube and then the rest. But there's a little bit more to that one. But if they file for Chapter 7 or if they're forced to Chapter 7 to liquidate, then once they're liquidated, there is no more license. Doesn't exist.
I do understand that.
Uh,
But currently, is it just
If
a
the
stay on the license,
Yeah.
or is the CCC revoking the license?
if the federal court allows the CCC to continue with its revocation deliberation, my recommendation would be for the governors. There's 5 commissioners, and 2 are vacant as of April 2030, rather. We need one more commissioner to be appointed and confirmed so that we can have 3 commissioners voting to revoke. Public Law 1856 says that there must be unanimous consent of the commission. And through a legal opinion, I was told that they need a minimum of 3. So right now, if they continue with the revocation, since I am recused because I'm the prosecutor, there's only a minimum of 2. So we need one more to effectively revoke without anybody challenging it. And I've asked Governor Palacios to please appoint, and I don't know why the appointment has not been made.
So how are you guys having meetings right
We
now?
can meet with 3, but I'm talking about revocation of the license.
But how can you meet to discuss anything to that extent when you have
3.
to recuse yourself?
No. The meeting itself is okay. Meeting monthly, 3 is enough to meet.
But you cannot discuss the revocation.
The
because-
the decision to revoke the license, the hearing part must be unanimous.
I do understand that. But you can be a part of the discussion when.
I'm the prosecutor,
But you can be a part of the discussion, is what you're saying.
prosecuting, but not as a tribunal.
Okay. So then how do you call a meeting if you have to recuse yourself? You can't be a part
no,
of the discussion.
We haven't. It's not a revocation meeting. It's a monthly meeting, regular meeting.
I do understand that it's a monthly meeting.
Yeah.
But when the issue pops up in regards
No,
to
I do not need to recuse myself on discussing it. I just cannot on the revocation. It has to be a separate hearing,
I do understand.
specifically for revocation.
And you would, I guess, recuse yourself from sharing information?
Yeah.
Or can you share
Uh,
information with
Oh,
the other?
yeah, I'm again functioning as a part of the prosecution to revoke.
Okay.
It's just the Administrative Procedures Act prohibits me to sit on the tribunal since I'm prosecuting it.
Okay. So now in regards to these three or whatever multiple license, that's coming from IPI to CCC or CCC to IPI? Because now we got to figure out who's leading this.
IPI was making an offer that they would accept removing exclusivity. They understood that previously CCC was saying we need at least, if you're asking to pay only 5 million on the casino license fee, we would need at least 3 in order for the government to retain back the 15 million. And they agreed that okay, 3 is okay with them. The company again that we have a stipulated agreement that they would retain 1 and that they would have the license reinstated. And then we were going with the understanding that they are committed to paying 75% of the 62 million and 75% of what they owe CCC. That was the approach when we were interrupted by several challenges from within the AG's office saying, first they're saying the payment that IPI needs to pay cannot come from the parent company. It cannot come from anybody else. It must come from IPI CNMI, period. I was going, does it really matter where the parent company is going to make the payment? And you're saying that to us? No. They're willing to do it. So I said, and then 2, do not negotiate what's currently due. You can only negotiate what was passed. I said, they were ready to sign. And then in the last minute, the monkey wrench was thrown in, and then it was just like when there was no more executive director, I told IPI, either you accept this, or we'll see you on Monday, which was the revocation. And then that's when they filed for bankruptcy, because we tried every effort to see how we can. In my opinion, Vice, it's best if we get 75% of what they owe versus penny on the dollar. But that's kind of like the ship is gone since they already filed for bankruptcy. It's already out of their hands. It's now in the federal court. So their suggestion was we give CCC $3 million. We give CNMI government the other $3 million. Of the $7 million that they borrowed, 400,000 has already been approved by the court, of which DPL got the 200 some already. Now, that would only allow them to identify all the other new partners in the reorganization for Chapter 11, which they have, because I asked them, identify now. They said no. They will do it in August. There's an August session by the court that they will prepare. If CCC agrees to reinstate, we will have stipulated agreement on how to pay the 62 billion, how to pay the remaining. Then they will identify the other partners in the reorganization, and then figure out a way moving forward on the August court appearance. But this is not a decision made only by CCC. The AG's office have to sign the stipulated agreement of which they were concerned about. And again, it's the last meeting I had, they were pushing for liquidation. And public land was there. And I said, well, I don't think it serves us well to go liquidation. I think it's best to talk about this thing and make an effort for IPI to pay rather than just everything is deaf. But I think once they file for Chapter 7, or at least forced to Chapter 7, I think at that point in time, then it's an issue of there is no entity, so license could be open.
But would still have to be revoked first. Because currently, if the lottery commission gives somebody else a license, IPI still has jurisdiction to, or at least some sort of authority to sue.
Yeah, the authority is suspended, or the license is suspended, so it's like that's good that they don't have it yet. Hasn't been restored to them.
It's true, but suspension and revocation are two different worlds, right?
Yes.
The revocation, it doesn't
Yeah.
belong to
Correct,
them, not
correct.
even any percentage.
Correct.
At least suspension is 50% not
Yeah.
working.
But my understanding is once you liquidate, you're nothing.
I do understand that, but if you look at all the documents, it still belongs to IPI, right? Because now we still need to consider the the land lease agreement also, because the land lease agreement that they signed with the DPO has all the financial stuff inclusive to it, which is a very good, actually a very good lease agreement written from our side to make sure that the investor is true to its word and give us accessibility to information that we wouldn't be able to get naturally from them.
Yeah, the agreement actually on behalf of the Commonwealth was really good. Problem was it's in a way too ambitious, and it's just too much that it's not realistic. How do you expect them to pay $20 million a year when there's no activity? It's just unrealistic. And I asked the owner, why did you agree to do this? They said, well, because they offered him the land, and it was the hotel. He was going to build several large five-star hotel, and then the hotel would help him pay the 20 million a year. And I said, how can that happen when your number of space is limited for gaming? And they said it would be the same as Macau, where all the hotels are on the site, and IPI would have the middle, the core, and then that's like the hub between all the hotels is where IPI would operate the gaming. Remember that the license agreement is very specific to the square meter of gaming floor. So on the Marpi side, he said he was hoping that when he gets the land, there'll be several five-star hotel will come in and join forces, and then they will share in the payment of that $20 million for the community benefit fund, even though it's not part of the law. Because for me, I did not understand why would you agree $20 million when you, first of all, like I said, it was supposed to be 60 days after groundbreaking on phase one, which never happened.
Sure, but back to kind of connect this back to the budget, that $7 million, that the $200,000 that went to DPL, the ask, whose ask was the 3 million distribution?
No, IPI first of all requested the court to approve that 7 million, and they had two exhibits, Exhibit A and Exhibit B. On Exhibit A listed all the employees that they have to pay, the insurance, the rental to DPL, to the lawyers, the bankruptcy lawyers. There's $400,000. The court approved that loan and approved the expenditure for that 400,000, and then the remaining 6 point something, of which includes CNMI government payment, 3 million to CCC. The other 3 million was to the CNMI government for a partial payment of the license fee. If they approve that, then they said we will move forward. But I'm not quite sure what's the status of whether or not the federal court. I think that was either today or yesterday, for the court to approve the Exhibit B.
Okay, so what if the 6 million was given directly to the central government, provided that $1 million is dedicated to the CCC rather than 3.3? Because it doesn't make sense. The 3.3 was a full functioning commission.
No, they wanted to give the 6 million to the CCC, and we're saying no, that's not going to happen. You got to give some to the CNMI government. So they said the license is being held by CCC. You know, Vice, I talked to the AG on this thing. I said, why is everything on CCC's hands? We're not even a signatory to this agreement. And he looks at me and says, because CCC is the only entity enforcing the license agreement. I said, then why are we have no support from the legislature, no support from the executive branch, no support from anybody, yet we get all the blame. I mean, it's like, wow. And we're all volunteering for a year and a half. It's like, this is madness. And by the way, we're already throwing the towel. I mean, like, no difference. But anyway, there's a lot of stuff that I'm trying to figure out what's happening here. Why isn't the lottery commission up front? They issued the license. Why isn't Public Works there? We've been arguing with them, take the crane down for 4 years. And they said, if that thing falls down and hurts somebody, I'll be the first witness against DPW. You know, because this is ridiculous. I asked the AG, if that crane falls down, who's at fault? My government. And thank God it's down now, but it was really sad advice. Like I said, we get a lot of blame. We have members of this body that will come to our meeting and tells us how incompetent we are and we should all resign. Thank you very much. You know.
Thank you for that. And yeah, well, we face the same thing, right? In this body, we get all the blame, good or bad, and that's fine. But I hope that that before we even get to any point in getting these fundings and the potential idea of the multiple license or a reinvestment to this industry, that we're hopeful that maybe with the support of the Casino Commission, that bill that's sitting in the Senate, 2396, is pushed out and get to the governor's desk so that we can really be in a true stance in one position as a Commonwealth, that the entity that should be getting these funds was the is goes back to its original intent of addressing the shortage of the retirees payment. And I would surely hope that from your side and the two sitting members that were members back then that change the intent would be in support of getting that bill onto the governor's desk so that any funding in the future, whether it's part of that $7 million distribution or the full payment, that would go directly to the retirees, 25%. I use my time.
Thank you, Vice Chair. Before I recognize Rep. Marissa, I have Rep. JP, then Rep. Manny, then Rep. Marissa.
Thank you, Chair, and good afternoon, Chairman. My first question would be, if I'm hearing it correctly, that as you were explaining, that IPI is agreeing to opening it up to 3 licensees, but with that IPI agreeing, are you saying that they get 1 license automatic if we're going to be opening it up to 3?
I think that was the intention, sir, that we reinstate their license back, and they will voluntarily agree to remove the exclusivity.
So that is part of the agreement, that they get that. And
We
in order to remove the exclusivity, but they automatically get 1 out of the proposed that you've been sharing of opening it up to 3, and then dropping the license fee from 15 and spreading it equally, 5 million for each license fee, and also spreading it the regulatory fees equally to reach what you are has been marked at 3 million plus.
that's what they're requesting. I think we made ourselves clear that we cannot agree to those multiple license, or because that's the function of the legislature and that's in the law. But we will not object if they recommend. There's a lot of stuff that they were recommending in there, like the reduction of the fees. That we CCC cannot agree to reducing that. That's the function of the legislature, but we will not object if they reduce the fee under the condition that there has to be other license issued to come up to the 15 million that the government initially needed.
And all of this discussion that you've made, CCC made with IPI, are these under executive meeting, or is this recorded? Any documented when they really agreed with you guys with this proposal?
Most of these discussions are in private, but I believe there might be some meetings where they're recording, where they actually say that they have no objection to removing exclusivity if they, if CCC agrees to. No, again, there's 2 phases here. First phase is to reinstate the license. It doesn't allow them to go operating a casino. The authority to go live is a separate issue.
I understand that. So my next question is, who are currently right now sitting in the commission?
There's only 3 of us: the Commissioner Ralph Mapan and Commissioner Mario Taitano.
Okay,
myself.
and when does your the 3 of you guys term mature?
Every commissioner serves a 6-year term. Ours is, I think, up in 2026, April 30.
April of 2026. Okay.
Yeah. And we only serve 1 term.
1 term of the, yes, absolutely. And the term of the members from Tinian and Aroda expired when?
April 30th, 2024.
2024, just this year.
Yeah, yes.
Okay. And you guys, as you mentioned, you guys are fairly conducting meetings regularly,
Once a month.
except except that you cannot hold a revocation meeting, as you have alluded that it's a must that you recuse yourself.
Yeah. The regulation says we must meet once a month. We're doing that. The revocation hearing has already started. Several hearing occurred. They're in the deliberation process now to actually revoke when the bankruptcy was filed and there was a stay. So if our request to the bankruptcy court to lift that stay to allow the commission to continue, the 1856 says that the revocation process requires unanimous consent of the commission. I sought the legal opinion from the AG, and they said that there has to be three making that decision to revoke. So since I have recused myself because there's nobody else to prosecute, there are no staff, no director. The AG also issued a legal opinion that says I cannot sit on that revocation.
Okay, and when is the last time you had a working director?
We actually lost the working director in January 2023. And then we got back for 2.5 months in January, February, and part of March 2024.
Okay,
Through that ARPA, I believe the funding, the limited funding.
that was given by Governor Palacios,
yeah,
right?
for the
As you,
revocation.
the process, right?
Yeah.
And if and when the bankruptcy court lifts up the stay, uh, is there any way you can conduct a revocation meeting absent a working director or a higher director?
The meeting itself, we don't need a director, only the commissioners.
For the revocation.
For the revocation itself, we will need three commissioners, and we're short one.
And maximum of three.
No,
and,
minimum of three.
Minimum of
Yeah.
three, and it has to be unanimous.
Yes.
All right. Thank you, Mr. Chairman. You for now.
Thank you, Rep. John Paul. We have Rep. Manny, then Rep. Marissa.
Thank you, Chairman, for your time here today. And thank you for the extensive presentation of what has transpired and all the training that was provided to CCC staff and commissioners. I guess this everything that transpired with this industry that was set up, it just proves the point that mutual exclusivity is not the way. When I first saw that, in fact, in the very beginning, when I was still at NMC, I just remember the private jet landing and a lot of people at that time, even at the college, a lot of students, a lot of staff were against the industry. Our people talked about that twice. Not talked about it, but voted against it. But the benefit was that this industry was going to benefit the retirees in the very beginning, and at the same time, I remember the late Governor Iloilo saying that the industry and what it brings is going to help transition a lot of jobs to the private sector, because the government is so big. And that's really what caught my eye is getting more people of our people into the private sector and not necessarily the government, because we can't sustain a big government and small private sector. But just the design of the industry, it kind of felt like we're giving one company the power to do what really the government should be doing in terms of licensing the casino. When you say integrated casino, basically one person gets the license, then they sub-license it to other providers, or which basically, yeah, we get a little money, but the sole licensee will get a bulk of it. Um, thank you for your recommendation. I think that, that's a very good recommendation. A lot of us were on the same page with that. I think in general, any industry, and let this be the example, that we should never go exclusive for anything. It's open market is always the best way for competition. And then at the same time, um, at the same time, with regard to the training, you know, we should be, up to par. We shouldn't be training our people after the fact, because that's when we get taken advantage of. Um, in that sense. So I know the college at the time was also working on adding a gaming component, the hospitality, tourism, and gaming, but it wasn't ready. But at the same time, I felt like, because this was a big thing that was kind of happening, but that was coming about, um, and we had people on the table like buying into this big idea, but it wasn't realistic, and it just proved that it was too ambitious. So hopefully this will be a learning lesson, not just for this specific industry, but for any industry that comes about moving forward, that uh, we don't put ourselves in this situation again. Thank you, sir.
Thank you, Rep Castro. Rep Flores.
Chair, could I make comment on his presentation briefly?
Sure.
Thank you, sir. There is no one, I believe, would agree that exclusivity is a desired route. But we need to remember that the Commonwealth Retirement Fund was on the verge of collapse. There was a clock that was ticking down, and the amount of investment required to be infused into the Commonwealth was so enormous that the late governor, I sat down with him and talked to him about this thing at length. They were required to put in the $1 million non-refundable. Then they were required to put in $30 million up front. The first and fifth year license was payable up front. And then within a short period of time, they put another 10 million in as contribution to utility. I don't know if you remember this. So it's easy to comment now, but we forget that there would be probably no retirement fund in existence if this help did not come in at the last minute to help. It's such a short period of time, hard to get a lot of people to come in to a small island and infuse that money. Cinema experienced an enormous amount of taxes that came in, not just from the gaming, but from the industries that flourished around. A lot of people had significant benefits from their value of their land. A lot of them actually leased their land for a significant amount of money. But, sir, I wanted to comment, because you said you're in the college. There's Section 15 of the license agreement require IPI to have at least 65% of the workforce local resident. We approached the college back then, the CCC, and we said, look, why don't we work together? And the president of the Senate was then Secretary of Labor. We worked with Labor and we said, look, this is a requirement of IPI. And we start talking with the college about setting up the so-called curriculum or something for the training. And then we told IPI, you pay for this training. And if NFC curriculum is going to open, you pay for a scholarship or some sort of that. So that discussion was actually going down that route, and I'm glad that you raised this training. It was a good design to begin with, and I believe that, unfortunately, with all the catastrophic events that have happened, the solar, the YouTube, the COVID, and everything else, it just collapsed. And in retrospect, sometimes we need to admit that we do make mistakes, but sometimes too we need to understand that those mistakes may have been inevitable. Remember, we have no control on our borders. We have no control on hiring non-resident workers. That's not in the hands of the CNMI. But yet, we all face the consequences. I think the Commonwealth was well prepared. The Commonwealth did its best, but it was circumstances that occurred simultaneously. First of all, this is the biggest mega project of its kind that the Commonwealth ever attempted to. That building down there is supposed to be a five-star building. If you see the 15 villas that was built, it is a five-star quality, the building itself. But what it required to be fully five-star is the staffing, of which you're working with NMC to see how that training can fill in that staffing requirement. But thank you, sir.
Just to add on to that, yes, there was a lot of funds that did come in. Aside from working at NMC, I also worked for Outer City Group. And when an investor is coming in and you don't properly vet them, you don't look at where they're coming from, the industry, this is what we end up with, unfulfilled promises. Whether it's IPI, whether it's Outer City, whether it's all the different investors that came in, and we're busy dealing with, I'm not saying specifically IPI, but we deal with too many middlemen. And yes, it sounds nice and all of that. But if our people are not trained to properly vet investors, and the investors are coming in and visiting lawmakers and politicians instead of visiting offices like CETA, and that's where we get into problems. So yes, a lot of money came through these doors, but it also came with a lot of problems. And having worked at Outer City, I've seen people come in and leave with envelopes. So we have to make sure that we're dealing with the right investors and not people that are playing games.
Two minor comments and very quick. The Lottery Commission, when they issued the license, they hired two vendors, B2G, to do the criminal and other probity exam, and they hired Innovation Group to do the business plan review. These individuals, they came back and submitted their findings to the Lottery Commission. They're the ones that did the due diligence, so-called due diligence report. And very quickly, on the Innovation Group, based on their report, the IPI's business plan would require a minimum of 2 million visitors a year in order for the return of investment to be realized. Obviously, Cinema cannot accommodate 2 million visitors at the time. But when they actually broke ground, they switched strategy and went into the VIP rather than to the mass media, because you need 2 million visitors playing in the US. Gaming is mostly on machines. In Asia, it's the table, the baccarat. So when IPI started out, they realized they could not get 2 million visitors here, so they switched and they went to the VIP and they used baccarat as a form. But Lottery Group did procure the services of two professional investigation team to do the due diligence.
Thank you, Chairman. Rep Flores.
Thank you, Mr. Chairman, and welcome, Chairman De Leon Guerrero. It's nice to see you again. Welcome to your house. I know we've met many times before, and many people can attest that maybe you and I have a love-hate relationship. But at this point, if I get too elevated in my voice, forgive me. I'm very passionate to protect the Commonwealth, especially the people of the Commonwealth. So you mentioned earlier that the sole licensee holder was arguing that COVID-19 was an act of God, therefore prohibiting the commission to actually go into any kind of discussion in regard to revocation. Well, we got to love Google, because now we just ask Google a question. And I asked Google a question and I said, is Google an act of God? Well, or COVID an act of God. And it said to me, the COVID-19 pandemic certainly counts as a global disaster, but whether it qualifies as an act of God is debatable. Most businesses' insurance policies specifically exclude communicable diseases like COVID-19 and do not consider them to be an act of God. However, what is an act of God is an uncontrollable event such as a tornado, flood, or tsunami not caused or controlled by humans. So, as we know, and history will tell us, COVID-19 was caused by humans. So it is not an act of God, which could have at least allowed you and the commission at that time when you had a quorum to actually act on the revocation. But here we are right now. One thing you also failed to mention was that during that time, you mentioned 1856 was actually passed. And part of that section in the law says the examination, supervision, and monitoring of the continuing fiscal and financial capability of casino owners, operators, concessionaires, and other parties with any direct relation to the sole casino, and to protect the public in the event that such capability is significantly diminished. Now, was it significantly diminished during that time of COVID-19? Yes or no?
First of all, Madam Flores,
Sir, it was a yes or no question, please.
we do not have a love-hate relationship.
Oh, thank you.
Second of all, the CNMI Supreme Court did identify and agreed the COVID-19 is a force majeure. So I would prefer to side with the CNMI Supreme Court than I would with Google.
Okay.
And also YouTube
Mhm.
would fit your definition
Mhm.
because YouTube is
Mhm.
nature.
Mhm.
So they're claiming that YouTube and COVID is a force majeure.
Okay. That's what they can claim. And you and I can agree to disagree
And
on
we
that.
started the sanction right after COVID.
Okay, good. Well, I'm glad. So, anyway, at that time, right, you had all this processes now happening. 1856 said, and again, and to protect the public in the event that such capability is significantly diminished. So, now you said that yes, it was, and because of that, now they were asking you for all of these other recommendations to help them now not pay a significant amount that was due because of this act of God. And at that time that 1856 was passed, let me remind you, sir, because we forgot apparently that the Speaker of the House was former Ralph de Mapan. When 1924 was introduced, a section of that was actually not even inserted in that bill because it took away the bonding, construction bonding, which again, this body by a vote of 13-7 approved that. And again, who was at the time the Speaker of the House, who is now your Vice Chairman of the Casino Commission. Moving forward, has IPI asked anyone in the commission to reimburse any expenses incurred by the commission since that time? Because we only gave you $1 last year. So you were operating at a dollar for your fiscal budget. At any time, did the Casino Commission ask for any expenses to be reimbursed by the sole licensee holder? Yes or no?
I think your question is a little bit confusing, Congresswoman.
What's confusing about it?
First of all, you're making allegations and you're jumping timeline. As I explained in my opening remarks, the CCC filed all of this complaint very early, right after COVID,
Okay.
to suspend and to sanction. When they filed at the Superior Court, we do not have the authority to tell the Superior Court to hurry up and act.
That's not the argument, sir.
No. You're defining to me what Public Law 1856 says. We did exactly our fiduciary duty. And if you understood what those complaints were, we prevailed. And the Superior Court was sitting on those actions. And then, like I said, you went all the way. And remember that those we were protecting because we were going after IPI. And
Sir,
it is at the hands of the Superior Court.
okay, I understand that. You took me through that timeline. I understand, okay?
So what?
My question was, at any time, did the commission request for any reimbursements for the expenses that you incurred with your $1 that was appropriated to you for fiscal year 2023 from IPI? Yes or no?
We did not
Okay,
request for the
thank you.
$1. We request for the
That's
$3
not my
million.
question.
We request for the $3 million that they are required to pay,
Okay,
not the $1. Oh, that's from the general fund. We have a lot of people that step forward and offer to double that, but the $3 million.
really? Like who? Who asked
A
to
lot
double
of the
that?
people, a lot of people who sat there on the opening says, "We feel sorry for you. Here's another dollar if you want." But we
Sir.
never asked IPI. Don't get me confused here, Congresswoman. CCC never asked IPI to be reimbursed the $1. We did ask them to pay what they are mandated by law.
Sir, excuse me, I have the floor here. And again, once again, I asked you a simple yes or no question. Did you ever ask the sole licensee to reimburse the commission for any expenses because you had $1 available to you for fiscal year 2023? Yes or no?
We did not ask to
Thank you.
reimburse. We asked them to
Thank
pay
you, sir.
the full amount. Not
Who did
the
you
reimb-
ask? You didn't ask. You asked us, correct? But we funded you $1. Am I right?
That is what. If you're not,
Sir, this is a hostile witness. I don't
I
know how
am-
to say it. Was yes or no? Did you ask? And you answered my question. You never asked IPI to reimburse the casino commission for any expenses, correct?
my God, Mr. Chairman, that is the very essence of the complaint we filed at the court. You failed to pay the regulatory fee. That is our bill. What is he asking?
I'm asking the commission. I'm not asking, did the commission, you, sir, as a commission chairman,
Yes, we did. We filed a litigation for IPA to pay.
okay, any other expenses, sir? Yes or no?
It's not expensive. It's the regulatory mandate they have to pay. We took them to court for
I
that.
understand that. Okay, moving along, because you and I
I don't
again
think
will
you
not.
understood what
I
you are
understood.
reading, madam.
I understood, sir.
I sure hope so.
I do.
Yes.
Nobody's insulting anyone here. You and I are not understanding each other. We can agree to a disagree on a lot of things. So, when you're ready, are you ready for the next question?
I'm here to answer questions, not
Good.
to be insulted.
So, you are now asking us for $4 million, correct?
No, I'm asking that the legislature appropriate what Public Law 1924 mandates for the CCC, for IPI to pay, which is $3,150,000 every year by October 1st. The law requires that I submit to the legislature for appropriations that amount, and I'm doing exactly that.
Okay, thank you.
Not to
Because
be insulted.
nobody's insulting you, sir. And I'm sorry you feel that way. Because in fact, if anything, I should feel insulted too. But I'm not saying that. I'm here to try to understand what it is that you are asking for. And based on what I'm looking at from our fiscal analyst, okay, $4.3 million should be enough to suffice. Okay, which are your total FTEs. Now for the commission alone, it shows, is this correct? 4 million for fiscal year 2025? TJ, is that it? This would be able to give the commission its powers and duties to commit their job, to do their job, correct? But that's what we're proposing here? Their proposed budget. So you're proposing for the fiscal year 2025, Mr. Guerrero, $4.3 million. Is that correct?
Madam, the local portion of that, the governor did not entertain that, so I'm not here to support the request for the local funding because the governor obviously did not entertain that. We do that as a matter of practice, just in
Okay,
case
so
we don't
then
get
you
it.
don't need the money.
I am asking for the $3,150,000 that Public Law 1924
Okay.
Mandates IPI to pay.
Now, so you're asking for the $3 million that is due to you, to the commission. Is that right? Or
Yes,
unless I'm
yes,
wrong?
Yes.
Okay. Now, what would you do with that $3 million, sir? Revoke a license?
No, if we get that, we would hire people back that we will need for the enforcement investigations,
Mhm.
audit, compliance,
Okay,
and so forth. Hire
Okay.
back the staff and
good.
start the training and so forth.
Training on a casino that's non-existent. So then my next question, sir, is during the time when all of the civil actions were filed against the department, I'm sorry, against IPI in the federal court, did the Casino Commission, you as a chairman and the rest of your Casino Commission members, did you not feel that at that time it was appropriate to investigate, sanction, and revoke the license of the sole licensee holder? Yes or no? And I think I'm going to yield after that until I go have everyone else ask. But the reason why I ask that is because you're now asking me for $3 million, or at least what is appropriate to you by law of $3 million, which I don't think would constitute for us to maybe negotiate into terms until you answer the questions where I think I would be comfortable, for the CNMI public to be comfortable, to give you $3 million. Because again, in all these budget hearings that we've been having, there are many other agencies that are short millions and millions of dollars, who are working every day, sweating under the sun, doing their due diligence for the people of the Commonwealth, following their mission, meeting their vision. So I'm just asking you, would that be possible if they give you the $3 million, sir?
Madam, it's in our system of justice. When IPI file their appeal to the enforcement actions that we have taken against IPI, CCC does not have the authority to bypass all the courts while they are still waiting to hear it. I don't know whether you have taken courses on justice and
Are
the
you
process.
insulting me, sir?
No, I'm explaining to you.
Okay, so
We
keep it
filed
clean.
we filed a complaint against IPI. We took it to the court. While the court is sitting on it, we cannot turn around and file more and more of the same. We have to wait for the court. And you're insulting me now to tell me that CCC is sitting doing nothing. When we're waiting for the court to make those decisions. We will be sanctioned by the court if they're still going through the process. I'm sure your legal counsel here can explain the
Sir,
process.
sir, I have the floor. Please, you can address me. So I am not saying that just on my own personal opinion. I'll tell you what, the people of the Commonwealth can tell you.
And you're not giving the $3 million, man. This is supposed to be coming from the operator. So whether you agree with it or not, it doesn't matter to me. Okay?
Mhm.
Because even if you appropriate, if there's no money, we get nothing. This is not coming from a source that you have control over. You don't. It's a soundbite that I really don't appreciate.
This is not
I
sound
come
bite,
here
sir.
in good faith.
And so, and sir, let me tell you, Mr. Guerrero, Chairman, I took an oath. So I will give you my respect as a chairman because you had to be vetted to sit where you're at. So I can respect that. But when the people of the Commonwealth demand answers after years and years of inaction by a commission, you can take that personally for you by yourself, or you can take it together as a team of your entire commission, because it's really sad for you to sit here by yourself without the rest of your two other commissioners who have been sitting there alongside of you when you and I would meet at your house at the commission. It's very sad. So I'm very sorry for you, sir, that you sit here all alone while your two other commissioners are probably watching on YouTube, while you sit here and take it in and assume that you're being insulted. But that's probably the difference between your generation and mine. We can take constructive criticism. We don't take insults. Because why? We empathize with people. We offer solution. We don't sympathize. So thank you, Mr. Chairman. I yield my time.
My generation,
Thank you, Rep. Flores. Any other questions with regards to the CCC? Being there's none, just one last question, Chairman, with regards to the regulation. You mentioned regulation that you have to meet monthly. Is that by law or?
it's on the Commonwealth Casino Commission regulations, the Commonwealth Register.
So it's
Yes, if we do not meet, we'll be negligent. We're not doing our fiduciary duty.
so with all the meetings that the commission has, there is unfunded liability because you're meeting every month.
Yes.
So is there
We are asking that the operator pay for it. That's part of
so
the
it's
regulatory fee
it's a running amount,
against the regulator.
right? So if the regular doesn't pay, it becomes a liability to the CNMI.
I don't know that.
You don't know, or it's
Well, right
it's
now, the funding is supposed to be paid by the operator.
right.
Sinabay government doesn't pay a penny, so we're hoping that the operator, the entity that's operating the casino, um, through whatever resolution, there's a so-called receivable on IPI. I mean the CCC from IPI, and when that is resolved, either through litigation or through bankruptcy, then that would be the source rather than the CNMA government general fund. But I don't know beyond that. Some would argue, yes, it is the Commonwealth's liability, and some would say, no, it's against IPI. So,
Okay.
like I said,
Yeah,
I-
no, we need
Yeah.
we need that amount because eventually the CNMI government's gonna have to pay for that because you're meeting with other commissioners, you're clocking in hours during those meetings. So obviously there is unfunded liability that's being done here, and I think uh, the committee would like to see that so that we can at least prepare should there be amendments to the law with regards to licensees. We will need to be upfront with that so that we know.
that explains why we requested the local funding,
Right.
the other million that was included in our budget requests.
Okay.
But since the governor did not include that on his balanced budget, we figured it's back to the usual, stick with your $2.
All right. With the and this is something that we're gonna have to, I guess, verify with the Secretary of Finance. And from the last audit report, there is funds remaining. We haven't seen the latest one. I believe 2020 was the last one, and there was over $1 million. I just want to just verify because obviously CCC is accumulating unfunded liabilities right now, and that's something that we're going to have to clarify with her from this moving forward. Now we have your executive director or former executive. Is he being paid? Is he working, or
No,
because everybody else has vacant on your submittal except Mr. Yom? Doesn't have vacant on it.
no, it's not being. It's
It's
not
not-
being paid right now. It's not an employee right now.
Okay, because everybody that was listed is
That was at the time that we had the 2.5 months. That's the period.
okay. Because of your special fund, there's a balance of $55,000 that's showing in what we have before us. So that's something you're gonna have to verify. It's your special fund has approximately $55,606 remaining in this special fund. So you're gonna have to get back with
$55.
$55,000.
Oh, I believe you're talking about the ARPA.
It's under the special fund. We're not sure.
Oh, okay, I understood that, sir. That's not, that money never really came to the CCC. That was the amount reserved for the arbitration. That was the amount that we asked the governor if we can tap onto it. And that was the amount that he gave us for 2.5 months. And up until now, there were some expenses that were incurred in that 2.5 months that have not been paid.
Okay, so this is
That's, I believe, the ARPA for that very
So this
short
is-
window.
ARPA fund then.
Yes, yes. We did, at the time that the federal court issued the injunction, the federal court imposed a $100,000 a bond. When they lost the Ninth Circuit hearing, the Ninth Circuit decision came out. we went after we went after that $100,000 to be refunded to the Commonwealth. The Commonwealth ended getting, I believe, 94,000 back from IPI for that arbitration, but that amount went directly into the general fund,
Okay.
not the CCC.
Okay. So this one is spoken for.
Yes,
It's zero
yes.
right now.
May not even be not enough for those that were incurred
Okay.
during the 2.5 months.
Okay. Okay. I put on hold here, so we're gonna verify with the Secretary of Finance when she does get here, with regards to the remaining, because obviously CCC is still meeting and we are clocking the dollar. So any other?
Yeah, I see I got that report from their budget, and like I said, this one never really showed up on the CCC's account. It's all managed by the governor's office, and it was originally 350,000 was originally reserved for the arbitration, and then
Is that the I think you're talking about the amount from DPW that's
No.
what's used.
no.
for-
This is the ARPA money that the former governor and the former secretary of finance reserved for the arbitration.
Okay.
That's the one that was used by it's mostly AG's office expense, not CCC. But when we saw some balance, we went in after the governor. We asked him, could we have a little bit of money just to complete the revocation? He gave us for the 2.5 months, using the leftover from the ARPA. But we don't. But this is really never funded into CCC. It was a special account under the governor's office.
Okay. Thank you for that, Chairman.
Yeah, I saw it too. The 55,000 there. That's it's not there.
Okay. Hey, wanna verify because I mean this is something that we look at and we're not sure because and that's why the members are verifying these accounts. Also, I guess I'll have one who hasn't spoken yet. Is it regarding the budget or? Okay. Repodon.
Thank you, Mr. Speaker. I mean, Chair. So you're asking for this amount so that you can employ 62 personnel, is that correct?
51 FTE, sir.
51 FTEs?
Yeah.
And do you already have those JVAs out and applicants?
No, this is a process. And by the way, Representative Don is very knowledgeable, sir. He's working for the industry and been before us many times to air the concerns of the community. So I appreciate your previous presence at CCC.
Thank you.
Now, what we're doing here, sir, is in response to the call for budget, and Public Law 1924 says that 3,150,000 is to be paid by IPI, and that amount must be appropriated by the legislature every year. So to be prudent, this is the timeline that we're asked to submit this before this deadline.
Right.
If we don't submit it by that deadline, then it means like we're not going to be appropriated if and when IPI. Remember, this is in the process of negotiating to get that money. If and when we get that money, we will use it to get back staff as we used to, the permit and licensing, enforcement investigations, compliance and audit division.
Right.
And most probably put out a JVA. We have a standing JVA. Some have expressed interest to come back if it's ever available, particularly those who are highly trained.
Right.
And those that we cannot refill, we just have to put a JVA out. But right now, there's no money and we can't put a JVA out. We're following the necessary protocol.
So, so you said that the funding that you're asking for is coming from the casino license, right?
Yes.
Has IPI paid their casino license?
No.
No, right? So how are we supposed to give you something that is not being given to us to appropriate?
Yeah.
You know, and then
And even if you appropriate, you're not giving it to me. It's just
Right. But then, you know, and the reason why I'm asking that name is because of that chapter 11, right?
Yeah.
So if they do get any money in, you think that they're going to be paying for that license or they're going to be paying for that chapter 11 bankruptcy court? Because, you know, today's newspaper, you know, about the debtors are not agreeing to the so-called plan that IPI has then that means that the remaining of the 7 million is not going to be granted.
Yeah.
So how are we supposed to give you
Yeah.
money that we don't have?
That doesn't
You
exist.
know, right?
Yeah, it's an interesting scenario, but the law is established in such a way that whether we get the money or not, it says on this date you submit that budget. If you don't, you pass the deadline, and you got to go before the legislature and get appropriated. But we've done this every year, sir.
Right.
You know, and because of that, we have over $12 million of every year, the 3 million since 2020. Uh, that's a receivable on our part. So when we do get it, we can spend it because we have the appropriate authority and appropriate appropriation.
$12 million.
Right now, it's $12 million from the regulatory fee from 2020, 21, 22, 23.
So we do have $12 million to
No,
appropriate.
those have been previously appropriated.
Previously
Yeah,
appropriated.
every year you appropriate.
Because I could tell you right now, like and like what Congresswoman Marissa Flores said that. I mean, I understand her frustration and all of that, because even the community are, laughing at this, request for funding for CCC, and like all the other agencies are having issues, and I don't think we just have that kind of money to be just giving to, something that is not as critical anymore. I mean, granted that we wish the casino succeeded, we wish that everybody succeeded, but it's not. So, and we don't have. Do we even have $1 to throw around? Because I don't even have a penny in my pocket. So I'm sorry, but this $4 million request for something that should have been done way back was, but that's neither here nor there. But I wish we could find some money to give you. That's just my opinion. Thank you.
Thank you, Rep. Odon. And before we go, the reason why, I mean, we don't appropriate funds to CCC. It's through the license agreement, but because we're trying to tie this in to the whole budget process, CCC can generate funds, and that's why we're here. I did get your email. We're looking at that now. We're just trying to clarify as to the authority of the recommendation you gave us, and we don't want to be in a situation where we're going to get sued now because we're discussing recommendations, and that's one thing that I want the body to be very clear about is. We did receive the recommendation you gave us. We're looking at that carefully, but also we need to know where does the licensee stand in a lot of this, because they can come around now and then sue each one of us for even discussing or even going outside looking for potential suitors that might be interested. There is a gaming law in the cinema that we have to look at. Now, if the people want to remove it, then that's for us to decide. But to that happens, we're here trying to find, I guess, some ways to generate funds, and that's why I'm trying to clarify with regards to the district where they at with this, because the district court is saying allow the filing of the I guess the bankruptcy proceedings, but then also they're allowing certain things. That's unprecedented right now for them to be interfering as to what IPI can go out and look for investors, but then they control which part to, or I guess approve the spending plan. So that's where we're trying to get at, Chairman, is how do we move forward, and how we open ourselves up to the possibility of trying to salvage what we have here. If not, then we know we're just gonna have to move on. Any further? Did you
Mr.
want
Chairman,
to?
yes,
Yeah, sure.
this entire process, the way this is designed, and I'm sure this is not unique to the CCC. where, and that's why the reason the governor puts out three different volumes of the budget. I believe volume one being the general fund. I'm on the autonomous agency volume, I think volume three, where the amount that we're seeking appropriations for doesn't really affect the general fund. So it's not like you're gonna take 3 million from some other entity of the Commonwealth government. It's not like that. The public law 1924 is specific to the Casino Commission, and the 3 million was specific for the CCC to use. It's not part of a budget that you can take and give to the hospital or give to public safety.
Right,
It's
but you,
not.
you did mention that part of the loan that was granted
That's
by
that's a
to
separate.
pay, right? But you did mention that, and that's where
No, but
your
that's
funds are going to come from.
no. What happened is that they currently owe the CCC 17 million,
Right.
which is 12 million
And they
from.
went out and applied for a loan, correct?
They went to apply
Or look for
after they
investors.
file for bankruptcy. First, they have to identify. They have to reorganize themselves. They don't have any money to do so. So they found somebody to loan $7 million.
Okay.
The court requires that the IPI identify the funding source and requires how you plan to spend it. They identified the individual, they identified the loan agreement with 10% interest rate payable by December of this year. And then they attached two exhibits. Exhibit A, which is $400,000. Those goes primarily for public land, employees, insurance, and the tax lawyers, the bankruptcy lawyers. The federal court already accepted the loan and accepted IPI's Exhibit A, accepted those to be used. The Exhibit B is where they're planning to pay the Sinema government the remaining 6.6 million. That's the one where the creditors are complaining, no, 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 you owe us. Why are you going to pay CCC? And they're saying that the value of IPI right now rests on the license, not the building itself. That if IPI were to reconstitute itself, it would be worth tremendously more if it has the license and the facility. If the cinema pursues liquidation, it would be worth only the facility, which is estimating 5 to 10 million only, given the current status, current state. So they're saying that it is in the best interest of the Commonwealth government, and I agree with them, that reinstate the license, increase its value, reconstitute itself, and whether they succeed based on that amended plan or not, the value is worth. So if it's subsequently liquidated, there will be more assets to distribute among the debtors. But as we speak, that 7 million is supposedly coming from an individual from Hong Kong. Like I said, 400,000 has already been approved by the federal court, specifically to pay ongoing expenses. And DPL is supposed to get over 200,000 of that.
So 6.7 is in roughly
Yes.
6.7 is in
The-
question.
Yeah, 3.1 million is supposed to be for CCC requested reinstatement of the license, and the other was to go to the Commonwealth government as part of the license fees.
And this is where the hiccup is at, because there's other, I guess, individuals that are trying to object to the
Yes,
how
yes.
the plan is going. Okay, so clarified. Thank you for that. Now, why shouldn't the CCC petition then the district court to allow the, I guess, to renegotiate? I'm not sure how it works anymore, but because in a way, see, the district court is involving itself, but it doesn't want to just do it straight out Chapter 7, uh, because of all the amounts they owe. So I guess my question is to allow um, that fee to be paid to CCC so that it can do its due diligence and there is some salvage then.
I I agree with that, Mr. Chairman, 100%. And on my meeting with the governor, lieutenant governor, the attorney general, and a lot of other lawyers, including public land lawyers, including Secretary of Finance, I said, let's give them at least a month,
Okay.
because the bankruptcy lawyer for IPS says that if we have an agreement on how that 6 billion is to go, it will be more favorable for the bankruptcy court to agree. But absent any kind of stipulated agreement, they're gonna have to battle with every other debtors. And now what I'm saying is, look, they're requesting that by June, which is I think yesterday or today, 3 million is supposed to go to CCC. And then they will begin the negotiation as to who's going to restructure, what company is going to come in, and how do they propose to pay the 62 million license fee? Because I'm saying that has to be paid. I mean, we're not going to negotiate that. But everybody in that little room is saying no. For 4 years they played around with us, it's like butterflies flying everywhere. Enough is enough. We're going to go and liquidate. Nobody wins on liquidations if you get a penny on the dollar. You don't have to be an economist to see that. I mean, it's just like, for me, I would prefer we negotiate, make an arrangement, make them reconstitute, and then they'll voluntarily give up exclusivity. We gave them a long list of what they need to do. You got to be bonded. You got to do all of this stuff. But I needed the legal sufficiency from the AG's office, and I was being told that the only way to do it is a way that was not suitable to this agreement, and it was just monkey wrench thrown into the stipulated agreement, and it
Right.
went nowhere.
Okay, thank you, Chairman, for that clarification. That's all I have. I guess we'll just wait for the district court to decide what to do with the spending plan. And then until then, the chair requests the updated unfunded liability that's currently accruing right now with CCC, so that we have a figure should all of this settle and there is no license. The cinema government at the end of the day is going to have to pay for the liability to CCC. So
I figure, Mr. Chairman, that even if everything collapses with IPI, and let's say that the legislature approves additional licenses, the CCC, being the regulator, would request that there will be an application fee. On that application fee, we can use that to pay staff to come back, and then there has to be due diligence, and those would have to be done by the regulatory body. So if nothing happens with IPI and it is liquidated, even if we get, like I said, penny on the dollar, if they owe us $17 million now, if whatever final liquidation, if liquidation is to occur.
all right. I guess we'll wait till we cross that road now before we
Yeah.
decide those.
Yeah.
Any further members? Do you have clarification? Okay, we'll have a rep. I thought that'd be the last, and then we'll wrap up.
Thank you, Mr. Chairman. Thank you again, Chairman. I know that the CCC is requesting for a budget in this fiscal year, correct?
Yes.
The only thing that I'm kind of concerned about it is, let's say that we find the funds and we give you the 3.1 mil or so, and you're not able to hire all the employees back, no? And in the fiscal year ends, you lose out because of the Planning and Budgeting Act. Because it's only within the fiscal year, no? Then we have to, it's not a carryover, unlike what you're receiving or previously receiving with the.
No, under 21-38, it carries over. There's no fiscal year limitation.
Yeah, but when we do it in the budget,
In the local fund, it would
yeah,
die at the
it
end of
would
the
die
September
every
30.
September
Yeah.
30, and
Yes.
that's just my concern.
Yeah.
So maybe what we can try to do is if we can find the funds within this fiscal year's budget, we can actually move maybe a smaller amount, so then we can find external sources to address the subsequent hires, no, so that
Yeah.
we'll be able to carry that over beyond the fiscal year.
That
So it's
would-
protected under 20.
That would die on September 30, following whatever.
Yeah, if we
Yeah.
just put it on
Just-
the
yes.
budget package, no, so
Yes.
everything that's in the budget package through the Planning and Budgeting Act would die out because we don't have the continuing resolution anymore when
Yeah.
the Constitution
Yes,
was
yes,
amended.
yeah.
The other thing that I wanted to ask, and this is regarding a quorum, and because you said that the AG's office had mentioned that it has to be unanimous, correct?
That's 1856.
1856
Yeah.
says it has to be
Yeah.
unanimous
On revocation.
on revocation. So even if they appointed one more person to the commission, and they all voted yes, it still wouldn't be unanimous because you're still a sitting member of the
No,
commission.
3 would be enough. I do not sit in.
Yeah, but unanimous meaning unanimous of the
people's-
membership or unanimous of
we-
voting?
I got a clarification on the AG on that. It's the people sitting on the hearing. I am not sitting on it. A company that there be a minimum of 3. It has to be the commissioner sitting.
So
on the
unanimous and voting.
hearing. Yeah.
I mean, present and voting.
Yes.
Meaning as unanimous is
yes,
defined that way.
yes,
Okay, because there's, like in our case,
Yes.
it has to be unanimous, meaning
Yeah.
everybody present and voting.
Yeah.
Okay.
We look into that. Several lawyers look into that. There was one that says unanimous consent of the commission means 5 because there's 5 commissioners. And through several legal research, I finally did an LSR to the AG, and it came out that says no, unanimous of those people sitting on the
Present and
yeah,
voting.
on the hearing. Yeah,
Okay.
as a company that you have at least 3.
Yeah, I just want to make sure that that's clear and it's on
Yeah.
record that
Yes,
they don't challenge you later on down the
it's
road.
we
that-
have a legal opinion on that. A company that there must be at least 3
Okay.
because that's the quorum of the 5.
Okay. I don't think we should talk like quorum,
Yeah.
and we should just talk unanimous and voting because
No, what I mean is there must be at least 3 commissioners sitting, and all 3 must agree.
yeah, and you need 3 to constitute a
Yeah.
quorum, right, to conduct
Yeah.
business. But I just don't want them to consider that the unanimous meaning including you as a recusal member.
The moment they get involved, it's another appealable issue that
Yeah.
should not even be there.
Yeah. Okay, so we'll work on that, and I know that there's other ideas thrown out there, but just to close out this meeting, the Commonwealth Casino Commission or the exclusive license is for the Commonwealth, correct?
Yes.
Not a specific island of the Commonwealth, correct?
You know, the Constitution, as you know, says that casino gambling is illegal in the Commonwealth unless approved by local initiative or by Commonwealth law. Rota and Tinian did it by local initiative. The Commonwealth law is the CCC. That's why we have a commissioner from Rota and a commissioner from Tinian. But we only regulate activities here in Saipan. We do not regulate any gaming activity in Tinian or Rota.
Okay, I just wanted to make that clear that the Commonwealth, although Rhoda and Tinian has their own
Yes.
referendums, no, that the Commonwealth's exclusive license belongs to the Commonwealth,
Even if you look back at the original intent of the 15 million license fee, 2 million went to Rota, 2 million went to Tinian.
which was supposed to be for the
Yes,
retirees,
yes.
but then
Which was happening in the first 2-3 years.
yes, and then the settlement fund got a hold of it because the third senatorial district couldn't afford it. A matter of fact, I think at points it was the first senatorial district that couldn't afford it as well because of the number of retirees that they had in their senatorial district. No, so I think and I hope that you support 23-96.
Yes, we
so
do.
we can.
We objected
that
to
out.
the original removal of that because of the revenue recognition issue. We advised the legislature then that you may not have a BGRT.
Mhm.
In fact, they may not be able because they're requesting a refund on overpaid or credit for overpaid taxes on the revenue recognition of the IRS.
Okay, and thank you for that. Thank you for your time again, Thank you, Mr. Chairman.
Thank you, Vice Chair. And with that being no further, thank you again, Chairman, for making yourself available today with regards to your budget request that was submitted to the administration. And being there's none further, Chair will adjourn at 3:52 p.m. Thank you.
Thank you, Mr. Chairman, and my generation. Thank you too.